How does divorce mediation work? Divorce mediation is an increasingly popular option for couples looking to end their marriage amicably and efficiently. Understanding how divorce mediation works in New York is crucial for those considering this path. Unlike traditional divorce litigation, mediation focuses on collaboration and finding mutually agreeable solutions without the adversarial nature of court proceedings. This process not only saves time and money but also reduces emotional stress, fostering a more respectful and cooperative environment for both parties. If you are contemplating divorce and considering mediation, it is essential to have the right support to navigate this process and consider whether mediation checks the boxes of your goals for your divorce. What is divorce mediation? Divorce mediation is a voluntary and confidential process where a neutral third party, known as a mediator, assists divorcing couples in reaching a mutually acceptable settlement. Unlike traditional divorce proceedings, which often involve court battles and adversarial positions, mediation focuses on collaboration and communication. In New York, mediation can help couples address various issues such as property division, child custody, and spousal support in a more amicable and efficient manner. The mediator does not make decisions for the parties but facilitates discussions to help them find common ground and craft an agreement that works for both sides. The role of the mediator. The mediator's primary function is to facilitate communication between the parties and help them through difficult conversations. The mediator helps ensure that both parties have the opportunity to express their needs and concerns, and assists in exploring various options for resolution. Preparing for divorce mediation. Preparing for divorce mediation is a crucial step in pursuing a smooth and successful process. By taking the time to choose the right mediator, gather necessary documentation, and set clear goals and priorities, you can approach mediation with confidence and clarity. Choosing the right mediator. Selecting the right mediator is one of the most critical steps in preparing for divorce mediation. A qualified mediator should be a neutral third party with a background in family law or conflict resolution. Gathering necessary documentation. Being well prepared with the necessary documentation can streamline the mediation process and ensure that all relevant information is on the table. Important documents include financial records, assets and liabilities, legal documents, expenses, and custody and support. Setting goals and priorities. Having clear goals and priorities can help you approach mediation with a focused mindset, helping address your most important needs. Consider the following. Identify key issues. Determine what issues are most important to you, such as child custody, spousal support, or division of assets. Understand your needs and wants. Differentiate between what you need to maintain your standard of living and what you want as an outcome of the divorce. Be ready to compromise. Mediation involves negotiation, so be prepared to make concessions while aiming for a fair and balanced agreement. Consult your attorney. Discuss your goals and priorities with your attorney to ensure they are realistic and aligned with New York divorce laws. Emotional readiness. Emotional preparedness is just as important as logistical readiness. Consider seeking support from a therapist or counselor to help you manage stress and remain focused during mediation. The divorce mediation process. Divorce mediation offers a structured yet flexible approach to resolving the many issues that arise during a divorce. Understanding each step of the mediation process can help you navigate it more effectively. Initial consultation and assessment. During the consultation, the mediator meets with both parties to explain the mediation process, discuss their roles, and outline the expectations. This session provides an opportunity for the parties to ask questions and express any concerns they might have. The mediator also assesses whether mediation is suitable for the couple, considering factors such as the willingness of both parties to negotiate in good faith and the presence of any power imbalances or domestic violence issues. Identifying key issues to resolve. The mediator helps the couple list all the relevant issues, helping both parties to have a clear understanding of what needs to be addressed. This phase involves gathering detailed information about the couple's assets, debts, income, and expenses. For couples with children, it also includes discussing parenting arrangements and the children's best interests. Negotiating terms and reaching agreements. The core of the divorce mediation process involves negotiating terms and reaching agreements on the identified issues. The mediator encourages both parties to express their needs and concerns while guiding them towards finding common ground. Negotiations may take several sessions, allowing time for each party to consider proposals and counterproposals carefully. Finalizing the divorce through mediation. Once the parties reach a consensus on all the key issues, the mediator assists in drafting the mediation agreement. This document formalizes the terms agreed upon during the mediation sessions and serves as a blueprint for the divorce settlement. Before finalizing the agreement, it is advisable for each party to review it with their respective attorneys to help ensure that their rights and interests are adequately protected. After any necessary revisions, the signed mediation agreement is submitted to the court for approval. Once the court approves the agreement, it becomes part of the final divorce decree, legally binding both parties to its terms. Challenges and considerations in divorce mediation. While divorce mediation offers many advantages, it is not without its challenges. Understanding these challenges and knowing when mediation may not be appropriate is crucial for couples considering this path. When mediation may not be appropriate. Divorce mediation is a collaborative process, but it may not be appropriate in every situation. Domestic violence or abuse. If there is a history of domestic violence or abuse, mediation may not be safe or effective. Such situations can make it difficult for the abused party to freely express their needs and concerns. Severe power imbalances. Significant disparities in bargaining power, knowledge, or financial control between spouses can hinder fair negotiations. In these cases, one party may be unable to advocate effectively for themselves. Unwillingness to cooperate. Mediation requires both parties to be willing to cooperate and compromise. If one or both parties are unwilling to engage in good faith negotiations, mediation is unlikely to be successful. Mental health issues. Severe mental health issues may impede a party's ability to participate effectively in mediation. Professional assessments may be necessary to determine the suitability of mediation in such cases. Potential obstacles during mediation. Even when mediation is appropriate, various obstacles can arise during the process. Communication breakdowns. Poor communication between parties can lead to misunderstandings and conflicts. Disagreements on parenting plans. Developing a mutually agreeable parenting plan can be difficult, especially when both parties have strong opinions about custody and visitation arrangements. Emotional intensity. The emotional aspects of divorce can create significant barriers to productive discussions. Strategies for overcoming mediation challenges. Despite these potential obstacles, effective strategies can help overcome challenges and facilitate successful mediation. Selecting the right mediator. Choosing an experienced mediator who is skilled in managing high-conflict situations and complex financial issues can greatly enhance the chances of success. Preparation and organization. Both parties should come to mediation sessions well prepared. Effective communication techniques. Mediators can employ techniques to improve communication, such as setting ground rules for respectful dialogue, using active listening, and ensuring that both parties have equal opportunities to speak. Professional support. Engaging financial experts, child psychologists, or other professionals can provide valuable insights and help address specific issues, such as asset valuation or child custody arrangements. Emotional support. Parties may benefit from individual counseling or therapy to manage the emotional aspects of divorce. Flexible problem solving. Encouraging creative solutions and flexibility can help resolve impasses. Getting the help of a skilled Manhattan divorce mediation lawyer. Understanding the importance of divorce mediation and how it works can significantly impact the outcome of your divorce. Mediation offers a collaborative and less adversarial approach, helping couples reach fair agreements on crucial issues like asset division and child custody. A skilled Manhattan divorce mediation lawyer from the law office of Besinque can provide the necessary guidance and support throughout this process. Contact us today at 929-251-4477 to learn how we can assist you in achieving a smooth and amicable resolution to your divorce.